instance, they will accept it. But it has happened, and from my reading of the respective inquiries and case dockets, it's clear that there's multiple references to the fact that upon a request being made to FSL, they were informed that they do not have storage facilities available, obviously based on a heavy workload. So there's multiple cases before this matters that needs to be dealt with before these exhibits can be submitted. So obviously it prolongs the submission of the exhibits to the Forensic Science Laboratory.
But surely there has to be proof that there was a request and that request was declined because of the workload, or that you must wait in line. It will take about 6 months for us to get to your consignment and test it. Is there any paperwork that reflects that all of that was done?
In some instances, yes, Commissioners.
In this specific case?
But no, predominantly it is inquiries that was made telephonically and then entries made in the SAP5, in the investigation diary.
Thank you, Commissioner.
Commissioners, what I can perhaps also add to my statement here, in this matter specifically, due to the proper manner in which the investigation was conducted, the evidence collected in this case was lawfully transmitted to the United Kingdom upon their request, obviously by means of a mutual legal assistance application, and the UK authorities managed to prosecute an individual in the United Kingdom and obtained a conviction on the matter relating to the facts of this narcotics. So it's just proof of the transnational nature of these offences.
General, let me apologize to you and Advocate Silo. My questions related to the Port Shepstone drugs, but in your further response, it seems like you were talking about what is in paragraph 5 of your supplementary statement. So my questions were aimed at the Port Shepstone drugs that went missing. So sorry if I was not very clear.
Perhaps, General, at least for the sake of tomorrow's readers, so that there is no confusion of the transcript, the question Commissioner Khumalo had posed was presumably any request to the FSL would be in writing. That was the first. And I think you confirmed that it is expected to be in writing and recorded somewhere, and where the FSL is not in a position to store the drugs from a recent seizure because of lack of space, they would equally indicate in writing. So there is a record of the request and how the request was dealt with. Would that be correct or not necessarily?
Commissioners, I'm not 100% sure in terms of the Port Shepstone matter. I was speaking in general about my observations throughout the inquiries that I've analysed. And there it's my observation that predominantly it's being done telephonically. So I'm not 100% sure in terms of the Port Shepstone matter. But I believe we can clear that up.
Thank you for that.
Okay, thank you. Which then, your answer raises a question for me. To the question Commissioner Khumalo posed, it would not be reasonable of us to expect the request and the response to the request to follow a stated format, be in writing, addressed to a specific unit head within the FSL and responded to in writing. That is not your experience and practice, so we should not expect that to be the case in all, if not most of the cases. And I'm relying on your experience here.
That's correct, Commissioners. But as I said yesterday, when it's inquiry investigations, and it's not, for instance, a court matter, there is not that pressure on the investigation team to get the investigation finalized like in a case docket. that is currently before court. And I've indicated that there is a mechanism in place where we can request the Forensic Science Laboratory to prioritize an investigation. But I think it's neither here nor there. It's important that whenever there is such bulk seizures being made, that it in any event, whether it's a case docket or an inquiry, needs to be a priority. And requests need to be submitted then to the Forensic Science Laboratory for urgent submission.
Thanks, General. I think perhaps I was somewhat inarticulate in my question. We are trying to determine what is the general process in engaging with FSL. Is there a prescribed process or manner in which a request to the FSL must be made? And does any protocol require that it be in writing and that FSL respond to that request similarly in writing? Is there such a protocol or not?
I'm not aware of such protocol, Commissioners, but logic dictates that if it's in writing, it cannot be disputed, especially if there's proof of
Yes.
a receipt.
Maybe, General, if you look at page 110 and see if that's the paragraph starting C. The heading is on 109, submission of illicit drugs for forensic analysis. And then it seems the discussion you're having with Ms. Sillo is covered at para 6. C rather, C and D. E even. And it seems that's all that regulates what should happen.
Yes, that is what I testified yesterday as well, Commissioner Baloy, is that upon submission of the exhibits to the Forensic Science Laboratory, it needs to be accompanied by this covering letter. That is acknowledged then, so you get an acknowledgement of receipt on the date that it was submitted. So that is indeed being complied with.
Okay, thank you.
Thank you, Commissioner Baloy. I think, and I'm going to test this, I think perhaps it's become clear in my head. The section that Commissioner Baloy just referred you to deals with the submission of the exhibits to the FSL, and it prescribes a process that must be followed.
That's
and
correct.
It does prescribe that there must be a written request and the like. The question, I think, General, why could I say General? Commissioner Khumalo. Umpteenth time, I do apologize, Commissioner. The question that Commissioner Khumalo and I think, were interested, the answer there to in, was relating to the request to FSL for storage, where FSL responds that it doesn't have storage capacity. So it's not the actual submission of the exhibits to.
Yes.
So then I'll take a step back. You remember in the morning when we started, I pointed out to your section of your statement, and I think General Musikiri also points out that when a request was made to FSL, it was rejected because FSL indicated that it was not a clean lab scenario. You recall that conversation?
That's correct, Commissioner.
And your view was that that rejection on that basis was correct because they ought not to have called FSL. It is LCRC they ought to have called. Articulate your answer, please, for the record.
You are correct.
Okay. So then we shouldn't confuse ourselves by seeking to find a formal written request to FSL for purposes of storage in circumstances where the exhibits were not being handed over to FSL. Would I be correct in that?
That's correct, Commissioner.
Okay. I think I'm clarified.
Advocate Silo, my concern, General, is looking at how the exhibits were stored and how they were recorded and the shortcomings that Chair listed yesterday. Remember, he went up to 9. I think Advocate Waloen Sillo added 2 more. From where I'm sitting, and I could be wrong, but it looks to me like there was never an intention to submit this drugs to FSL. There was never an intention to have them tested. Because of how they were handled throughout and how they were recorded, it raises concerns to me that it doesn't seem like there was ever an intention that these drugs will go to storage in Pretoria or that they would be tested so that we can be 100% sure that it was cocaine, 541 kilograms of it. Because I cannot understand how there is no paperwork saying to FSL, at some point when you do have capacity, we would like you to take these drugs. We would like for them to be tested so that we can ascertain that this was indeed cocaine. And if there's a need for people to be arrested and prosecuted, that can be done. What is your comment on my observation? I'm not stating facts, I'm just stating an observation.
Commissioner Khumalo, you are 100% correct. I also referred to that yesterday in the same manner as you have summarized it now, that it's my strong view that there was never an intention to submit it to FSL. And that's why I'm reflecting now on all the other cases where predominantly the crime scenes were dealt with correctly and the exhibits found its way into an SAP 13, remained in an SAP 13 at the police station. It was never stolen or tampered with and then submitted to the FSL. Whether it was a year later, I think for purposes of this exercise, it's irrelevant. The fact of the matter is it was not stolen at the police stations and it arrived at the Forensic Science Laboratory intact.
Thank you, Commissioner Khumalo. And General Flynn, I think we're dealing with the matter at your paragraph 5, that incident that you said there was liaison with the British authorities and resulted in convictions in the UK. Are you in a position to comment about any prosecutions or convictions arising from that drug seizure of 8th May 2020 in South Africa? It's a yes or no. If you don't want to unpack, you don't have to. I just want to know what progress South Africa has made.
There was no prosecution up to date in South Africa, Commissioners.
No prosecution to date. I'll leave it there. I'll not probe any further. Getting back to your statement, if we look at your table, I think we are now at the third item, the 2021-02-23 matter, where under place and commodity you indicate Greenpoint. I'm correct, right? Now, actually, we should be dealing with the 2020 August 11.
Yeah.
The cocaine burst of 20 kg. That's our next matter.
That's correct, Commissioner.
And you unpack that at your paragraph 6, so if you could take it from
correct.
there.
On 11 August 2020, members of the DPCI Durban Serious Organised Crime Investigation Unit followed up on information in relation to a container that was on the vessel Polonia that originated from the port of Santos in Brazil. The vessel was on anchorage before entering Durban Harbour. Upon further investigation, 20 kilogram bricks of suspected cocaine was recovered from the container. The cocaine had the Audi logo on the wrappings of 10 of the bricks. The other 10 bricks had no logo on. The crime scene was properly dealt with in terms of crime scene management principles. The exhibits were photographed and sealed in forensic evidence bags. The mass of the suspected cocaine was 20 kilograms. The exhibits were booked in at Durban Central SAPS under a reference number Then the exhibits were submitted to FSL in Amanzimtoti on 1 September 2021, and then FSL confirmed that the exhibits were cocaine. And then the case was investigated under a certain reference number. And here, Commissioner, there's 2 cases where LCRC did not attend to the crime scene. But the investigators, and it's not clear what was the reason for the 2 incidents. It is then this case and the Manuchar case. LCRC did not attend to the scenes. But the investigators themselves complied with directives by having contemporaneous notes, by taking photos of the exhibits, and properly securing it by sealing the exhibits there and then where it was recovered from the container.
Before you move off that point, is it your testimony that it is imperative at all these seizure scenes that the LCRC be present, or it is not necessarily a requirement? What is the actual position?
It is very important, Commissioners, especially when it comes to the prospects of lifting fingerprints and touch DNA, which cannot be performed by an investigator. Although an investigator can take photos, compile it into a photo album, and ensure that the chain of custody is maintained and the integrity of the investigation is upheld by properly sealing the exhibits in exhibit bags. Investigators are not capable of performing that 2 very important aspects.
And in this case, I think you specifically pointed out that the risk of non-attendance or attendant on the LCRC not attending the scene was somehow ameliorated by the actions of the investigators themselves. Is that correct?
Yes, some of the tasks were performed, Commissioners, as I've indicated. But the reason why the investigators moved in here and conducted the investigations was that they had to beat the criminals to the vessel, and specifically the container. So there is an acceptable explanation for what transpired here. It's not clear in the Manuchar matter why Colonel Sabia did not summons LCRC to that matter. But in this matter, and I have the detail of the matter which I prefer not to disclose
Please don't.
to the Commission, I'm satisfied that there was no wrongdoing on the part of the investigators in relation to this seizure of the 20 kilograms from the vessel.
I don't know if the commissioners have caught on the DPCI language. There is this case you keep, is it Manucha? Is that our Port Shepstone matter, the Durban seizure of 22 June 2022?
No.
Okay.
The Manuchar seizure is a complete separate and non-related matter.
Okay, I'm clarified. Then my question is, in the Port Shepstone matter, the one that we've been dealing with, the LCRC did not attend the scene. Do you have an understanding of why that happened? Why the LCRC did not attend the scene at the harbour during the seizure of the Port Shepstone?
It's because they were not summoned, Commissioners.
They were simply not summoned.
That's correct. Colonel Jacob indicated that he called Forensic Science Laboratory. But there was no indication that he ever requested the presence of the LCRC. And that was the important section to be present at that incident.
And when you deal with this case, you do point out that LCRC as well did not attend, and you gave explanation for why that was the case. But you went further than to say the failure to call LCRC in this particular instance was addressed by the steps that the investigators on the scene took. Did I understand you correctly?
That's correct, Commissioners.
Now, if I contrast that with the Port Shepstone matter, where similar steps taken from the records that you have been able to go through, were similar steps taken by the investigators to cover for the absence of the LCRC on site?
By no means, Commissioners. There was just a few photos taken of the exhibits there at the police station at Isipingo, few photos of the exhibits in the container, and shoddy work, to say the least. It was as if the investigators were in a hurry.
And lastly, I think you made the comment that you understood why the LCRC was not called to the scene on the day in respect of this seizure we're talking about. And if I heard you correctly, you said they were trying to beat the criminals to the container. Did I understand you correctly?
That's correct, Commissioner.
So there was a level of urgency in that case.
Indeed.
Did the same level of urgency attach to the what I'll call the Port Shepstone seizure?
No, Commissioners.
Thank you.
But at least it sounds like at best you would say that no agency has been claimed for the absence of the LCRC in Port Shepstone.
Well, Commissioners, as explained by Colonel Jacob, he indicated that the scene became busy with the perhaps individuals arriving at the warehouse yard. But I also explained that that's a controlled environment already per se, as it's a warehouse. And it could have been easily contained where an outside perimeter and inside perimeter could have been deployed. And they could have decided how big that perimeter needed to be in order for them to properly deal with the scene. I also said that there was no need to transfer the crime scene or the exhibits seized from the crime scene to Isipingo before all the necessary investigations were done at the container.
I guess importantly, really, the question is, has Colonel Jacob anywhere stated or given a reason why the LCRC was not called? We know he called the FSL, that's what the records show, or what is alleged, but he hasn't said anything about, or has he said anything about why the LCRC was not called?
I'm not aware of the detail in relation to that aspect, Commissioner Baloy.
Thank you, General.
Thank you, Commissioner. General, I think then we are ready to turn to your case number 4, which you deal with from your paragraph 7.
On 23 February 2021, members of the DPCI Durban SOCI followed up on information in relation to a container that was at Green Africa Container Yard. SARS Customs detected narcotics during a search of the container, where 495 packages, and it was in total 9.9 kilogram, containing methamphetamine was seized from where it was hidden in the cargo in the container. The crime scene was properly dealt with in terms of crime scene management principles. The exhibits were photographed and sealed in forensic evidence bags. The exhibits were booked in at Brighton Beach SAPS under a reference number, and the exhibits were submitted to FSL in Amanzimtoti on 19 April 2021. FSL confirmed that the exhibits were methamphetamine. The case was investigated under a Durban reference number.
Noted. Is there anything you would like to highlight there in particular?
No, this is just the last matter, Commissioners, that was submitted to FSL in Amanzimtoti. As I said, that's the smaller seizures, the 9.9 kilograms, the 20 kilograms of cocaine and the 35 kilograms of cocaine was submitted to Amanzimtoti due to the capacity aspects.
And I note that on the point you just made, at your paragraphs 8, 9, and at 8 and 9, you deal with 2 other seizures and these were submitted to a different FSL. Am I correct?
Just a quick one. If I'm not mistaken, General, you said that the referral to the FSL should be immediate. Am I correct, or have I forgotten?
You are correct, the Chairperson. According to the protocol, the exhibits must be submitted within 7 days.
Within 7 days.
Obviously.
Yes.
No, sorry, Commissioner.
I'm saying I'm looking here at 23 February and a referral on the 19th of April, almost 2 months later.
Yeah, indeed, it's non-compliance with the protocol, Commissioner, but I'm not in a position to comment on the reasons for that.
Yes, all right.
But I think what's important, and that's the point that we want to drive home, is that
there was a referral.
There was indeed a referral, although it has fallen outside the 7-day period, but the exhibits arrived at FSL intact, accepted, analyzed, and we received a report.
Except that perhaps the longer the period before the referral, the more the possibility of something going wrong with the exhibits, either them missing, being tampered with, or whatever else.
You are correct, Commissioner. The risk obviously remains,
yes,
that there might be tampering with the exhibits. It's indeed true.
Thank you, General.
Thank you, Chair. Then, General, we turn our attention to your paragraph 8 at page 4.
On 30 July 2021, members of the DPCI Durban followed up on information relating to the possible smuggling of narcotics concealed in a shipping containers destined for a major truck assembly plant in Gauteng, Scania. When the container doors were opened, the officers noticed black bags inside the container. As the officers suspected it to be bags of cocaine, they halted the process until LCRC arrived. And this is the matter I spoke to yesterday as well, Commissioners. There was proper crime scene management as the scene was investigated for fingerprints, DNA, and photographed. A duplicate seal was recovered from the container. 29 bags, each wrapped in black tape with carry handles exposed, were recovered. 999 bricks of cocaine were recovered from the bags. The mass of the cocaine was approximately 1,000 kilograms. The narcotics were transported to Maiden Wharf SAPS, where they were booked into the SAP-13. It's alleged that the suspected cocaine could not be submitted to FSL as they did not have enough space in their vaults. The exhibits were accepted by FSL in Pretoria on 12 November 2021 after the burglary and theft of the 541 kilograms of cocaine at Port Shepstone.
So is your paragraph suggesting that some good came out of the theft of the cocaine at Port Shepstone? Because then this seizure could be accommodated at FSL in Silverton.
Well, very, very shortly after the burglary was detected, Commissioner, I believe that my counterparts at Forensic Science made the means to accommodate this major seizure, and then it was submitted.
And this was 1,000 kilograms, about twice the size of the Port Shepstone seizure.
That's correct, Commissioners.
That's it. Thank you. You may proceed.
On the 16th of February 2022, members of the DPCI Durban SOCI, in conjunction with Crime Intelligence, followed up on information in relation to a container that was at Manuchar warehouse where 550 bricks or 550 kilograms of suspected cocaine were seized from where they were hidden in the cargo in the container. The container originated from the port of Santos in Brazil. The crime scene was properly dealt with in terms of crime scene management principles. The exhibits were photographed and sealed in forensic evidence bags. The exhibits were booked in at Umbilu under reference number, and then the exhibits were submitted to FSL in Silverton on the 24th of February 2022. FSL confirmed that the exhibits were cocaine, and it was investigated under a Durban SOCI reference number. Commissioners, this is the other matter where LCRC did not attend the scene. It's not clear why Colonel Sabia did not summons them, but from a study or an analysis of the inquiry, it's clear that there is contemporaneous notes. The exhibits was photographed and then properly sealed in the forensic bags before submission.
But you would, because LCRC wasn't there, you still miss the DNA evidence that you might have been able to pick up in fingerprint.
Indeed, Commissioner Beloy, that's correct.
Yes.
It's a shortcoming.
And the referral to FSL here was relatively quick. The discovery is in February and the referral is in February still. The one just before that, the one involving the truck assembly plant, that's about 4 months.
Indeed, Chairperson.
Yes.
Thank you, Chair. Thank you, Commissioner Baloy. And did you, unless I missed it, did you indicate whether you are aware why LCRC was not called for this particular heist?
It was not established as yet. I have not consulted Colonel Sabia on that matter, Commissioners.
Thank you. And so Colonel Sabia, would that be the investigating officer, or why the particular colonel?
He was the senior member at the crime scene and then also the investigator of that matter, Commissioners.
Thank you, noted. You then deal with the last matter at your paragraph 10 overleaf at page 6.
On 28 November 2022, where members of the DPCI SOCI attended to a crime scene at R&D Port Operations, where 60 bricks, 60 kilograms of suspected cocaine was seized from where it was hidden in the cargo in the container. The container originated from the Port of Santos in Brazil. The crime scene was properly dealt with in terms of crime scene management principles. The exhibits were photographed and sealed in forensic evidence bags, and then the exhibits were booked in at Brighton Beach SAPS under reference number Brighton Beach SAP 13, and the exhibits were submitted to FSL in Silverton, and they confirmed that the exhibits were cocaine. The matter was investigated under a Durban reference number.
And would we be reading your statement correctly, where you conclude on each case by referencing the investigation number, case number, but you say nothing further about that no convictions as yet have been obtained in respect of any of these seizures? Would that be a fair conclusion to make?
That's correct, Commissioner.
I will not inquire into the reasons thereof. I just wanted to establish the status of prosecutions and convictions, if any.
No, there was no convictions or prosecutions in any of these matters, Commissioners.
But you consider them live and ongoing matters?
Well, that's part of the inquiries that I summoned and retrieved from KZN, and there's ongoing investigations, Commissioners.
Thank you. I'm happy with that.
General, is there a standard, for a prescribed standard for where to store seized narcotics in the same way that you have a standard about how to store firearms? You know, it has to be in a particular safe, as I understand, a safe of a particular type. Is there such a standard which would inform, let's say, generals, to use Potchefstroom, that would have informed General Sinona that this is not an appropriate place to store and rather go to, I think you say, let's say Brighton Beach, because it meets the required standard for storing of narcotics? Is there anything like that?
Commissioners, I'm not aware of such a standard, but that's why it's important that, and if a specialized unit need to establish its own SAP 13, I believe that's part of the considerations that the national head would have taken into consideration before approving or disapproving such an application for an SAP 13 at the unit. Inter alia, is it just a strong room, or is it a properly built up walk-in safe with proper doors, for instance, locking systems, alarm systems, not just in the safe but outside, perimeter fencing, beams, etc. All these considerations. So I think that's the important part here, is to during that consideration phase, whether there is additional safeguarding in place or not.
Thank you, Commissioner, and thank you, General. On that point, perhaps for completeness, it might be worth our while to refer to your annexure HFF2. We've dealt with this before, and that is the National Instruction 8 of 2017. Commissioner Baloyi had requested had asked whether there are protocols around dealing with seizures of this nature. I would like to refer you in particular to page 86 under sub 8, and I think that is the main paragraph starts, if I can find my place, I think it's 12. It's 11, it starts at 79, paragraph 11. At page 79 under the heading property, then it deals with various kinds of properties, and specifically at page 86 sub 8 it deals with drugs, and it speaks to a protocol that must be adopted in the storage of the specific drugs as are listed there. And overleaf at Roman 7, which then would be paragraph 11, sub 8, sub B, sub Roman 7, would then deal with the issue of the sealing and forensic evidence bags, and have to be marked with the SAP 13 number. You are familiar with the protocol set out here?
Yes, I'm fully au fait with specifically 8B, Commissioners. I think 8A is perhaps the most minimum requirements. I cannot think that it's exhaustive, and that's why I said I'm not aware of a specific protocol in terms of the requirements for an SAP 13 facility. But it just makes sense that there need to be additional safeguards to ensure that criminals cannot get to the actual exhibits that's placed in a walk-in safe.
Thank you. I just wanted you perhaps to comment on that as well, to add to the response you gave to Commissioner Baloyi. We then I think we are now at your paragraph 11.
That's correct.
Of your statement at page 6. If you can then take the commissioners through that.
From the aforementioned, I was able to ascertain that unlike the June 2021 seizure, 11.1, LCRC was called to the scene to process the crime scene in respect of all the other seizures, except for the second Polonia vessel seizure and the Manuchar seizure, as I explained earlier. All the exhibits were sealed at the crime scene. No samples from the exhibits were submitted to FSL whilst the exhibits were still in storage. There is no record that the sealed evidence bags were opened at any time before all the exhibits were submitted to FSL. And then all the bulk exhibits were submitted to FSL in Silverton, except for the three exceptions that I've highlighted.
Just 2 seconds, General.
Just to clarify, at 11.3, you say no samples from the exhibits were submitted to FSL whilst the exhibits were still in storage. So the booking, I thought the evidence we had involved that some 7 bricks were taken out supposedly for...
Commissioners, this referred just to the cases that I've explained here now.
To Port Shepstone in
It does
particular.
not relate
Okay.
to the Port Shepstone matter where samples were taken
Okay, thank you.
and then submitted to FSL
Okay, thank you
in
for clarifying.
Amanzim Toti.
Thanks for the clarification.
Thank you, Commissioner. You may proceed, General.
And that's the end of this statement, Commissioners.
Is there anything you would like to add to your supplementary statement before we turn our attention back to your conclusion in your main statement?
No, Commissioners.
Unless there are questions on the further questions on the supplementary statement, Commissioners, I would invite General Flynn to go back to his original statement, and at paragraph 25, you then deal with the conclusion.
Page 25, paragraph
25.
69.
Paragraph 69, page 25.
Thank you, Commissioners. The persistence of drug trafficking at an organized crime level is often facilitated by the complexity of modern supply chains and involvement of officials who exploit positions of trust within logistics, border control, law enforcement, or commercial processes. Trafficking networks or syndicates are deliberately structured, which makes detection more difficult. Efforts to counter this form of organized crime require coordinated intelligence-driven action across multiple agencies and, importantly, embracing technology. While enforcement efforts continue to disrupt operations, bringing the perpetrators to account is difficult due to the clandestine nature of the crime and the involvement of law enforcement officials and border control. In my opinion, the cocaine seized in 2021 should never have been stored in Port Shepstone. The crime scene management failings compromised the integrity of the investigation, and the subsequent theft of the cocaine was severely compromised our ability to find the traffickers. I trust that my evidence will be of assistance to the Commission.
Thank you, General. Before I turn to the Commissioners, are there any other comments you'd like to make, having then read out your conclusion?
No, Commissioners.
Chair and Commissioners, yes, please.
General, what I'm going to ask you is unrelated to your testimony, but I hope you will be able to comment on it. What protocols exist with regard to the conduct of polygraph tests, or what are colloquially referred to as lie detector tests? What protocols exist, and when is that usually or ordinarily done, and who gets subjected to it?
Commissioners, in terms of our legislation, I believe it's section 17E, speaks to integrity testing. And as part of that process, polygraph tests are also part of the machinery that is deployed to determine deception or whether individuals were perhaps complicit in the commissioning or taking part in any offence. And then it is upon the national head to then direct who needs to be exposed to that process. So then a list is then submitted to the identified officers, who then needs to report for such polygraph testing.
And do you have any idea as to what the determinant factors are to decide on who should be subjected to the test?
I believe the merits of each matter, Commissioner, will determine whether an individual or individuals be exposed to the process. So I don't think there's hard and fast rules associated to those decisions. It will be dependent on the specific facts that such a decision will be taken.
I was avoiding specificity so as to get an idea of the generally applicable prescripts, but perhaps I should be specific now. The facts here are that General Sinona was involved in the decision to take the drugs, the cocaine, to Port Shepstone, and in the end he kept the key. I'm just trying to establish in my own mind whether he ought not to have been subjected to a polygraph test. I'm asking this in the context of the fact that there were polygraph tests here, and I assume that everybody who was involved in all of this saga was subjected to such tests, but he was not. Ought he have been subjected to the test, in your view?
In my opinion, Commissioner, indeed, he was supposed to be exposed to the process, as he played an active role in the Port Shepstone matter. It's not as if he was just the provincial head sitting at a distance. He was privy to the activities. He visited the Port Shepstone offices shortly after the seizure and took possession of the key. That's active participation. It's not as if he was at a distance and that he was not related to this matter. So it's my strong opinion that he was supposed to be exposed to the process.
Thank you, General.
General, I wanted to follow up on Commissioner Baloy's question and the answer you gave, more for clarification than anything else. Were 7 bricks ever taken from Port Shepstone to the FSL lab for testing?
No.
They were not?
It was never submitted, Commissioners. It was, apparently there was a request for 7 bricks of cocaine to be submitted, yes. But I clarified that point in terms of the process that the investigators would have followed, but it was only the samples that the investigators obtained on the second day when they went back on the 24th.
Yeah.
So obviously opening the exhibits, obtaining that samples, sealing it, submitting it to FSL, that was the only samples that was submitted, Commissioner.
So the 7 bricks were never taken?
That's correct.
Yeah, okay.
That's correct, Commissioners.
Thank you.
General, we see here Warrant Officer Mpangase is quite the active person with this inquiry. If this were an investigation, I would have assumed he was the investigating officer. Does it mean he was in charge of the inquiry? Because remember we start off, you said yesterday that Colonel Jacob was the person in charge of the operation. and then he went off. Then you have Mpangase, who seems to be very busy here. Would he have been, therefore, the owner of this inquiry?
Indeed, the owner of the inquiry, Commissioner Baloy, in the sense that he's the investigating officer.
Okay.
But in terms of command and control, the responsibilities of the team leader, which will obviously be a captain or at the level of lieutenant colonel, the unit commander, the provincial commander, as well as the provincial head, under these circumstances where it's a major drug seizure, cannot be wiped out. They've got certain responsibilities in terms of inspections and overseeing the investigation, obviously from a higher level. But to ensure that the investigation is properly conducted, all the possible leads are followed up, exhibits are submitted to FSL in time, or then assist if there's blockages in all these processes to ensure that there's a smooth transition of the exhibits from the SAP 13 facility or wherever it was kept to the forensic science laboratory.
Thank you, General.
Thank you, Commissioners. Thank you, Chair. Unless there are no further questions, if there are no further questions for General Flynn, that is the testimony of General Flynn. Thank you, Chair.
Thank you very much, General. You are excused, but perhaps you should wait for the formal adjournment.
Yes, indeed, Chair. Insofar as the next step is concerned, General Flynn will then be excused, which means we finish at lunch. The next witness, unfortunately, is one who has to travel into Gauteng, and today is his travel date to Gauteng, and can only be presented tomorrow at 9:30 in the morning.
Is that because he could not travel earlier?
The arrangements that had been made already had been for him to travel today, to be present at 9:30 tomorrow morning. In light of the fact that there is no threat that he may overrun, we thought it was appropriate to retain the arrangements as were made to cater both for his overnight stay in Johannesburg and travels, and to be presented in the normal hours tomorrow. So we request that perhaps with your leave we stand down at this juncture to 9:30 when we start with a new witness.
Thank you, Ms. Sillo. Let us adjourn until 9:30 tomorrow morning.
Thank you, Chair.
Yeah.